Hi, everyone. Thanks for joining us today. I'm just going to give another minute for people to finish coming in and settling in, and then we will get started. Hey, everyone. Thank you for joining us today for NASDAQ's webinar, A Brave New World, Understanding the Legal Frameworks that Govern HIV Data Use and Sharing. I'm Dori Molizanov from NASDAQ, and I'm joined by Amy Killalay, who's a consultant for NASDAQ. This webinar is being recorded, and we'll share a recording and the slide deck later this week. And there will be also time for questions and discussion at the end. Please put questions for presenters into the Q&A box. This is the box that has 2 speech bubbles. This is better for us than using chat for questions. The chat has 1 speech bubble. Otherwise, I might lose your questions and we might miss them or not notice that you've asked them. So please use the Q&A feature for that. And if there's something that you'd like to share, if there's something that you'd like to share with all attendees, like a comment or a resource, you can use the chat for that. So questions in the Q&A, questions for the presenters rather, and thoughts, comments, resources, etc. for the audience can go in the chat. So even though this is funded with the CDC cooperative agreement, just want to share that the content that's discussed today does not reflect the views or opinions of CDC. So this is the first webinar in a 2-part series. For today, Amy will kick us off with an overview of how health departments navigate privacy laws and policies to be more effective in their programs. Then we will talk about what those privacy laws are and how they intersect with HIV data use and sharing for public health purposes. Specifically, we will talk about HIPAA, state HIV confidentiality laws, privacy of substance use data, and minor consent laws. And then we'll have ample time to answer questions and provide space for you all to hear from each other about your own work and experience. This was initially planned as a learning collaborative, but even though we decided to go with a webinar format instead, we still want to create a space for sharing and bring all of you into the conversation as much as possible. So hopefully folks came today prepared to share some of their thoughts, challenges, experiences, successes, etc. And then we will also, I mentioned this is a 2-part series, so we will have a second webinar in September. I'm going to drop a date and time for that into the chat right now, just so that you all can save the date, and then you can look out for an email with more detailed information in the next week or so. So now I'll turn it over to Amy to get us started.
Awesome. Thank you very much, Dori. And hi, everybody. It's great to be here. And yeah, as Dori said, we're going to do a couple of things, and we're gonna go deep on some of the state and federal statutory schemes that govern data protection, data privacy, and data release. But what we wanted to do first, and we're trying this out, we're going to come full circle to this at the end, but we wanted to start out with a grounding in the why, of sort of the what do you all as public health program leads out there in jurisdictions, what are the facets of data sharing, privacy, and confidentiality that are important to getting you from point A to point B in terms of whether it's implementation of ending the HIV epidemic, initiatives, strengthening programs. So we thought we'd start with a few examples of sort of connecting the importance of understanding the legal and regulatory scheme around privacy and public health innovation with regard to data. So next slide. So, there are likely countless use cases here, but we wanted to start with three to get us going, and then we certainly want to hear from you all too of what drew you to this particular webinar and this particular topic, and how you're sort of connecting the data privacy and confidentiality and security statutory schemes to the work that you do. But the first one is really the foundational one that sort of comes up probably most, and certainly has driven a lot of the work that NASDAQ has done over the years. And that's really about linkage and retention. So linking folks who potentially are out of care back into care, retaining folks in care. And there, when we talk about data sharing and data use, we're often talking about one of two things, and sometimes both. We're talking about sort of one directional data sharing, where either the data is being shared out and we're sort of focused on that, or one set of data is being shared in, and that's it. It's just one way data sharing. And then sometimes we're talking about bidirectional, where maybe a health department program is sharing data with another entity or agency, and that entity or agency is sharing data back. So for all of the different examples that fall under this large category of linkage and retention, the legal scheme is important, and sometimes it's different depending on what you want to do. So anything that contemplates sharing of releasing of HIV surveillance data, and that can be across within the health department with a Ryan White entity, or the program that oversees Ryan White, or we can be talking about even outside entities. But if we're talking about release of HIV surveillance data, we're talking about state laws, and Dory's going to give us the overview of the state statutory regulatory scheme that is specific to HIV surveillance data. If we're talking about using data from other sources, like for instance, there's been a lot more talk about prescription drug data and using prescription drug data to identify folks who are potentially out of care and relinking them, re-engaging them in care. There, you get into a completely different statutory scheme. You're still talking about state law if you're talking about surveillance, but you're also talking about HIPAA, which we'll talk about if you're talking about the data that is held by pharmacies, a HIPAA covered entity. If you're talking about data sharing with electronic health records data, so you want to do some sort of data sharing or data use with an electronic health record provider system, there again, the state law might govern a portion of it, and HIPAA is going to govern any provider has to comply with HIPAA. So that's sort of the first use case. If we're thinking about any sort of data to care or data to linkage and retention, we have to think about the different types of data schemes that are going to govern each data set. Next slide. And then our second example is a little bit more straightforward, but no less important. And that's the data. This is more sort of data importing rather than necessarily data sharing or bidirectional data sharing, but looking at a surveillance data set and thinking, okay, there are other data sets that would help keep this surveillance data more updated. And that might include data matching with other jurisdictional surveillance data sets, but it also might include, data matching or importing data with other data sets in the state that might just have more updated or more granular information that can then, add to, strengthen, make more accurate your HIV surveillance data. And there, state law, again, is going to be the governing law for surveillance data, because that's a little bit of it is a distinct type of data set with distinct type of state protections around it. But anytime you're getting to sort of external data sets, you also have to think about what other statutory schemes are governing those data sets that you might want to import. So it's always looking at start with what entity you're representing, and then look at what type of data you want to get in, and if there's another statutory scheme that governs that. And then next slide. And then the last use case is more of a policy use case. We know that HIV criminalization law reform has been a longstanding priority of NASTAD and of NASTAD's members, and even of NASTAD's sister organizations like CSTE. And so there's a large portion of that advocacy work that focuses on the the criminal statutory provisions of those laws, but there are also there's also, I think, a growing awareness that within those statutory schemes, there are also data protection pieces that either firewall public health data from law enforcement and from criminalization activities. And when I say that, I mean prohibit, for instance, surveillance data held by the health department from being used ever, subpoenaed, court ordered, requested in a criminalization in a criminalization proceeding. So that is a very strict provision that is often, part of the conversation when you're talking about reforming HIV criminalization laws. So that's sort of another, understand, what does your state statutory scheme say about health department surveillance data, and the extent to which it can be used, it must be used, or it is prohibited from being used for criminalization and for other law enforcement proceedings. So hopefully that gives you a little bit of a sense of the landscape, and we'll go to the next slide. What we wanted to do, just to kind of get you thinking, and as Dory said, we want this to be as sort of interactive as possible, and we're going to come back to this, but Mentimeter, hopefully you guys are familiar with that. You can scan the code that you see on your screen right now using a tablet or a smartphone. You can go ahead and click the link that Dory has just placed into the webinar chat. You can go to menti.com that you see on the screen and then enter that code. So all sorts of ways to get at it, but however you choose, if you can go ahead and open the Mentimeter. And how else are you envisioning data sharing and using data sharing to strengthen your programs? And you can take this as broad or narrow as you want to. We're interested in what drew people to this webinar, like what types of data sharing are you interested in that you want to sort of learn more about the statutory and regulatory privacy components. So we'll give you a minute to fill that out. And I'll say too, if we already hit on one that you used, that's okay. You can repeat it and tell us, what's important, what types of data sharing is top of mind for you, and is important for you all to learn about the legal scheme. All right, great. All right, so we've got the updating surveillance data, looking at partner service collaboration with SCD services. All right, so a lot of sort of syndemic, breaking down silos with other programs and other data sets, cluster detection and rapid start, syndemic projects, community partners. That's great. So looking outside of the health department with data sharing, and housing. So other programs maybe outside of the public health and infectious disease programs. Awesome, Ryan. Wide eligibility requirements. Okay. All right, this is great. This is awesome. I think what we'll do, collaboration with EHE and Ryan White, A, B, and ADAP. Okay. So this is great. We're gonna go ahead. So feel free to add to this as we go. We're gonna like lock this in, and we're gonna come back to this. We're gonna come back to this at the end. So we will revisit this, but have these types of data sharing in your minds as we go. We want to make this sort of as practical for you all. I think Dory and I would love nothing more than to sit in on just kind of a recitation of state and federal statutes on data privacy, but we want this to be not just that. We want it to be as relevant as possible to your day-to-day. So with that, I'll turn it back over to Dory.
Great, thanks, Amy, and thanks to folks who shared. We look forward to digging more into some of those examples a little bit later today. So one thing that Amy highlighted is that the entities that are providing information to a health department typically have to comply with different privacy protections than the health department does. So one source of such protections is HIPAA. So let's talk about HIPAA today for a little bit. There's a lot to say about HIPAA, and we're just going to cover some of the basics and how it operates and how it intersects with public health. I am also going to share a few links in the chat right now. These are resources that I find to be personally extremely helpful. And I would definitely recommend bookmarking these if HIPAA is coming up regularly in your work. So with that, let's get started. So the two key components of HIPAA are the privacy rule and the security rule. These rules govern how certain healthcare entities protect and secure certain kinds of information. The security rule, which we're not going to talk about too much today, establishes administrative, physical, and technical standards for ensuring that electronic health information is confidential and secure. But for most people, when they think of HIPAA, they're usually thinking about the privacy rule. Who can access their information and why? In other words, how can their information be used and disclosed? So when I say use of information, I mean how an entity shares, analyzes, or uses information internally. And disclosure refers to communicating information externally. So HIPAA does allow information to be used and disclosed, but it puts parameters on what can be shared, with whom, and for what purpose. The privacy rule assures that data is properly protected while still allowing the flow of information that's needed to provide high quality care and protect public health, which I think is what I would say is the general underlying principle you see throughout HIPAA, that it's about striking a balance between privacy and the need to share information for certain purposes. HIPAA does not apply to every situation involving any kind of healthcare information. It applies only to certain entities called covered entities, and it applies only to certain types of data called protected health information. A covered entity is either a healthcare provider, a health plan, or a healthcare clearinghouse. So a provider is a doctor, a nurse, or hospital or lab is subject to HIPAA if they transmit health information electronically in connection with certain transactions like electronic billing and referrals, for example. So I think given how many electronic transactions are occurring in the healthcare system today, I think it's safe to assume that pretty much any provider that you see is going to be subject to HIPAA. For example, many Ryan White grantees are covered entities because they provide healthcare services and submit electronic insurance claims. And then there are some entities that are definitely not covered by HIPAA, which include employers, schools, a lot of state agencies like Child Protective Services, and law enforcement agencies. So that's not to say that the information in their possession is freely disclosable, but it just means that HIPAA is not going to be the source of protections for that information. Health plans, another type of covered entity, include health insurance companies, HMOs, most group or employer health plans, and government insurance programs like Medicaid and Medicare. To bring back the example of Ryan White, programs like Ryan White that provide grants or direct funding for provision of care are not considered health plans, but again, many Ryan White grantees could still be covered by HIPAA as providers for at least some of their activities. And healthcare clearinghouses are entities that process electronic information like billing companies. HIPAA also only applies to certain types of data, protected health information, or PHI. PHI is individually identifiable health information that relates to someone's health condition, the services they receive, healthcare services they receive, or payment for their care. PHI can include information in a medical record. It can include demographic data, conversations between providers about care and treatment, billing information, and much, much more. It's also not limited to electronic information. It applies to paper and oral information too. So again, conversations between providers are subject to HIPAA. HIPAA only applies to identifiable information, which is an important distinction. Identifiable data is data that either identifies someone directly or that reasonably could be used to identify someone, for example, by filling in a few missing data points. So truly de-identified information does not fall under HIPAA protections, which means that HIPAA does not restrict its use and disclosure. It's possible for a data set to be missing some components and still be considered identifiable under HIPAA. So that's something to keep in mind, is that HIPAA has its own standards for determining whether information is de-identified. Public health departments often perform the functions of a covered entity. For example, health departments often operate hospitals and labs. They administer ADAP programs. Health departments do have to comply with HIPAA when conducting these kinds of activities. But health departments also do things, traditional public health activities like disease surveillance, that do not fall within HIPAA. Therefore, public health departments are often hybrid entities, which allows them to carve out traditional public health activities from their HIPAA obligations, which is not to say that those activities have no privacy protections. Again, they're just protected by different laws. So now let's talk about the intersection of HIPAA. Sorry, I have a little bit of a lag on my screen, my slides. The intersection between HIPAA and public health. In general, under HIPAA, a covered entity must have a valid patient authorization to disclose PHI. A HIPAA authorization is a detailed, specific, written and signed permission for a HIPAA covered entity to use or disclose PHI for a specific purpose and duration. It can be revoked by the patient at any time. This is different from consent. Consent usually refers to giving permission in situations where HIPAA doesn't require an authorization, or perhaps where HIPAA doesn't apply at all. So you might give written or oral consent in a healthcare context for a number of reasons. For example, many of us have provided informed consent to receive care, or have given permission to our provider to submit insurance claims on our behalf. There are medical standards of practice. There are state laws that require consent in certain situations, and sometimes providers voluntarily choose to obtain consent. But if it's a situation where HIPAA requires an authorization, these kinds of consent are not going to replace that. There are a number of situations where patient authorization is not required for a covered entity to use or disclose PHI. There are only two situations in which a covered entity is required by HIPAA to disclose information. So what that means is that if a situation has arisen where the covered entity is being asked to disclose this information, they don't need a patient authorization, and HIPAA also doesn't really give them the space to refuse to do it. So that's what's meant by a required disclosure. There are two types of required disclosures. If a patient asks a covered entity for an accounting of how their information has been used or disclosed by that entity, the covered entity must provide that information to the patient. And second, a covered entity also must disclose in PHI in connection with HIPAA compliance investigations. So this is when the U.S. Department of Health and Human Services is investigating or enforcing HIPAA. The covered entity does not need a patient authorization, again, to disclose for these purposes, and also does not really have the space to, for all intents and purposes, we can say they don't really have the option to, to not share. This is something that they have to do, assuming that all other requirements are met. And then there are also 6 categories of permitted disclosures. So these are, again, situations where patient authorization is not required, but also, at least as far as HIPAA is concerned, the provider is allowed to use or disclose information, but is not required to do it. I'll elaborate a little more on what that means. But essentially, for now, we'll just say that what it means is that the covered entity does not violate HIPAA if it discloses. It also does not violate if it refuses to disclose. So here are the 6 categories of permitted use and disclosure under HIPAA. I bolded the ones that I think are the most relevant to you all and to our discussion. So treatment payment and healthcare operations are one very important type of permitted use and disclosure, and probably the one that folks come into contact with the most. This is what allows covered entities to use and disclose health data for the purposes of providing treatment, paying for services, and doing other activities like quality assurance. Some examples, my specialists share test results with my primary care provider, and my provider submits claims to my insurance. I'm sure most of us here have given written or oral permission for a provider to share information in this way, but again, it probably didn't rise to the level of that really detailed and specific written patient authorization that's required for disclosures that don't fall within these categories. And since health information has a lot of important uses outside of the healthcare context, HIPAA permits disclosure for certain public interest and benefit activities. Each of these has specific conditions and limitations to balance the individual privacy interest against whatever public interest might be served by disclosing or using the data. So 2 of these public interest and benefit activities allow HIPAA covered entities to share certain data with public health authorities. Those are disclosures required by law and disclosures for public health purposes, public health activities, sorry. And I also included here disclosures to law enforcement because I know that this is a major concern in the community. So I wanted to clarify whether and how HIPAA comes into play for that. So as a permitted disclosure, again, a covered entity can disclose or refuse to disclose without violating HIPAA. Of course, as long as all relevant requirements within HIPAA are met. However, there may be a state law that requires disclosure, even though HIPAA does not. In that case, that state law will generally prevail, and the covered entity is ultimately required to disclose, and HIPAA allows that, meaning they don't violate HIPAA by sharing that information. Oops, sorry, I'm just making sure that our recording is working. Okay. So another type of permitted disclosure is for public health activities. A lot of disclosures that are made for public health purposes are already required by law anyway. So for example, state law requires reporting of HIV test results to the health department. But there may also be emergency situations that are not specifically addressed in state law where public health officials need PHI to deal with an emergency effectively. So in this case, under HIPAA, a covered entity may disclose the information to the public health authority, again, subject to limitations and parameters. And finally, HIPAA permits but does not require a covered entity to disclose PHI to law enforcement in specific situations and subject to appropriate process. So if a covered entity gets a court order or a subpoena, HIPAA does not prevent them from responding to it, but they still have to follow HIPAA parameters when doing so. So it's important for a covered entity to understand all of its legal obligations when it gets a request like this. It's also important to know how to push back if needed, or at least make sure that the disclosure includes only the minimum necessary information. And I also want to note that just because data can be disclosed to a law enforcement entity does not mean that it can or will be used in a legal proceeding. There are rules in the legal process that must still be followed. So just because HIPAA allows disclosure does not automatically mean that the data is admissible as evidence in court. So now I want to walk through a quick example. So I hope folks are ready to do a little interactive question. I'm going to launch a poll in a moment here. I'm going to launch a poll has a question which folks can go ahead and respond once you feel like you know the answer. So the question is, under HIPAA, specifically HIPAA, may a healthcare provider report new cases of HIV, which including PHI, to the state health department without the patient's permission? So we'll give folks a minute, not maybe 15 seconds to think about it and put in some responses. So far, we are seeing a lot of folks saying yes. Some I'm not sure, some no's. Okay. Great, thank you for participating. So the answer is yes. So folks who said yes, that was the correct choice. Every state has a law that requires providers to report new cases of HIV to a state or local health department. So because this is required by law, by state law, HIPAA allows the provider to disclose to the health department without the patient's written signed authorization. In theory, the state law could require written or oral permission from the patient before the provider reports data to the health department, but HIPAA does not require this. Actually, I'm not aware of any states that do, but theoretically, a state could pass a law that is more protective than HIPAA in this way. Since I mentioned it earlier, I just want to briefly explain accounting of disclosures. This is one of the two situations where a covered entity is required to disclose PHI without patient authorization. Essentially, this is when a patient requests a list of prior disclosures of their PHI. So if the PHI was shared with a public health authority, even for surveillance purposes, this generally must be included in the accounting of disclosures. The same thing applies if the covered entity shared the information because of a court order. So even though the patient's authorization isn't needed for the disclosure to occur, the patient does have a right to know that the disclosure happened. So in the wake of Dobbs, the Supreme Court abortion case overturning Roe v. Wade, there has been some heightened criminalization of reproductive health care and specifically abortions. So things like self-managed abortions, miscarriages, traveling to other states to obtain care, these things are crimes in many states, which they were not crimes even at all before. As a result, more people are traveling or using telehealth to obtain abortions from providers in states where it's legal. But if the patient lives in a jurisdiction with very strict abortion laws, there's a concern that their PHI could be disclosed to law enforcement in their home state and then used to criminalize them for seeking lawful care. So to address this, the administration released new federal HIPAA regulations a few months ago. HIPAA regulations now explicitly restrict sharing information with law enforcement if it relates to reproductive health care that was obtained legally. These regulations are not applicable directly to HIV data, but I wanted to mention them because I think that we can take something from this as we continue working towards shoring up HIV data protections on the state and federal level. So the new HIPAA rules are based on an underlying premise that individual and public health is compromised if patients can't trust and undermined if patients can't trust that their information is private, and that fear of criminalization undermines the patient-provider relationship and even discourages people from seeking care altogether, which of course is not news to a lot of us here, but it is significant, in my opinion, to see it stated so explicitly in these federal regulations. The new regulations also clarify that criminalizing people for seeking care is not a public health activity, and therefore HIPAA does not permit disclosure for that and under that kind of exception. HIPAA rules about data sharing for public health purposes are not actually changed as a result of this rule, but I just think that it is an important recognition that data connected to bona fide public health activities like HIV reporting generally should not be used for any other purpose, and certainly not to criminalize people. Again, these new rules don't directly relate to HIV, but I think that it's significant that these concepts are recognized explicitly in federal rules and regulations, and I believe that this will inform future advocacy to strengthen HIPAA protections for HIV data and other types of data. So we talked about when covered entities can disclose HIV data to a public health department under HIPAA, and so now I want to talk about what happens to that data once the health department has it. So if we follow this flowchart for a health department, on the first question, is the entity a HIPAA? Is the entity a HIPAA covered entity? We already hit a dead end here because health departments are not covered entities. So that means that HIPAA does not apply, but a state privacy law might apply. Also, I should clarify, I know I said that they are hybrid entities. We're talking here about the health department when it's doing its traditional public health activities, not in its any kind of like care provision role, like operating a lab or a hospital. So is the entity HIPAA covered? No. But before we move on, let's just walk through the rest of the flow chart. Anyway, if the entity is a covered entity, then the next question is the information public health information, PHI? If not, then HIPAA doesn't apply. And if yes, then the next step would be to determine whether this situation is one of the exceptions under HIPAA that does not require a signed written authorization from the patient. And then proceed with following HIPAA and any other state other applicable laws or policies for use or disclosure of that PHI for that purpose. But again, HIPAA does not generally apply to public health data. So what law does? Just to walk through this diagram, over on the left, we have providers and labs. These are HIPAA covered entities, so a PHI in their possession is subject to HIPAA. This includes, for example, various types of HIV test results. These covered entities share PHI with the state health department as required by state law, which again is a permitted disclosure under HIPAA. Once it gets to the state health department, HIPAA no longer applies because collecting these reports and conducting disease surveillance based on that information are not HIPAA covered activities. The health department is not wearing its covered entity hat here. And then further use and disclosure is governed by other laws, federal, state, and or local that authorize the health department to use or to collect, use, disclose the information to aid in its public health mission. So our goal at NASDAD is to support health departments in their work while also ensuring the strongest possible protections to prevent misuse of data, especially in a context where it's being misused to criminalize people with HIV. There are multiple tools available to health departments to enable them to protect HIV surveillance data. And the first important protection I want to talk about is state privacy laws. All states have some laws that address confidentiality of public health HIV data with varying levels of protection and detail. These are generally structured as blanket confidentiality protections with specific exceptions. These state laws can, depending on the situation and where you're located, can be amended to limit or prohibit disclosures for non-public health purposes like prosecutions. And health departments can inform legal and policy reform by centering evidence-based public health practice in advocacy efforts to change harmful laws. Of course, we know that in some states, the health department direct involvement in legislative changes can be very limited. But even whether it's advocates or the health department itself that's working directly with decision makers, the health department still has an important role to play to provide the evidence and make the public health arguments for change. I've put here an example of a protective law from Maryland, which says that certain HIV data collected and maintained by the state health department can only be used and disclosed for the purpose for which it was obtained. It also specifically prohibits this data from being admissible as evidence in legal proceedings. But of course, a lot of states are either more permissive than Maryland when it comes to how data can be used or disclosed. Or that a lot of states even more so don't provide guidance in the law, much guidance in the law at all. So this is where health department policies and practices come in. In most states, health departments have a lot of discretion in how to respond to external requests for personally identifiable information. Many of you here probably live in states where statutory changes are unlikely in the foreseeable future due to politics. And so health department discretion is especially important here where the laws are vague and change is maybe not on the horizon. So each health department really does have to look at what are the laws and policies in their state related to public health activities like surveillance and determine how they can comply with those laws while accomplishing their public health goals and preventing misuse of data to criminalize and marginalize people with HIV. So to that end, we at NASDAD strongly encourage health departments to work closely with their public health legal counsel to ensure protective interpretation of data privacy laws, especially when laws are broad or vague. We also encourage and support health departments in their work to engage communities in dialogue about HIV data privacy by discussing community concerns and providing information on safeguards that are already in place. These are some important ways that the health department can engage with the community and have that dialogue about HIV data privacy in a public way. On this slide, I've included also a link to a tool developed by NASDAD that summarizes legal protections that limit or prohibit disclosure of public health data in each state for law enforcement purposes. So I'm going to drop that into the chat. It's been updated not too long ago, and we update it regularly, typically about annually. So please go ahead and take a look at that. There's some other resources on that page as well. And finally, wrapping up here, so I can pass it back to Amy. I just wanted to talk quickly about prosecutorial and law enforcement practices, which is a third and important tool, not all three, but it's the third I'm talking about today, important tool for health departments to protect HIV surveillance data. Health departments can and do engage criminal justice stakeholders in changing HIV criminalization and data privacy laws. One way to do that is to inform prosecutorial discretion that's grounded in current medical knowledge. So I have an example here from New Jersey, where the Office of Attorney General issued guidance to state prosecutors on how to approach charging people under the state's HIV criminalization statute. This guidance acknowledges that HIV criminalization exacerbates stigma and that enforcement of such laws can undermine public health. And it reflects a position that charges are rarely, if ever, appropriate. So prosecutors considering such charges in New Jersey must consult with the state's Department of Justice. So there's also an additional layer of review there when charges are being considered. HIV advocacy groups have also successfully forged partnerships between public health officials and prosecutors to collaborate on ways to reduce prosecutions of HIV. And in New York City, the health department has worked closely, the city health department has worked closely with law enforcement to expand supportive community-based services for sex workers. So I'm going to drop links for some of these into the chat. And then please, of course, feel free to reach out if you'd like to learn more. Okay, one last slide here. I just want to talk about implications, limiting principles of health department data release, and kind of some things to have in our minds as we're continuing to talk through and think through today and in general how to shore up HIV data privacy protections. So how does everything we've talked about relate to HIV surveillance in particular? So although HIV surveillance is not a new activity, it's risen to public consciousness more in recent years because as data and technology are advancing, there are new concerns about potential for data misuse. We don't have evidence right now that surveillance data is being disclosed for criminal proceedings, but we still want to make sure that our protections are as strong as possible because it's possible that that could change. So here are some factors that limit disclosure and relevance of surveillance data for criminal legal matters. First, we already talked about statutory protections. The ideal is for every state to have a law that just prohibits disclosure for non-public health purposes, full stop. Unfortunately, most state laws addressing health department data are not that explicit and specific. So even so, though, we do read these laws with HIV surveillance in mind. And some laws are vague enough that they could arguably include these activities, even if they didn't even exist when the law was written. And as public health interventions and data continue to advance over time, there are potential future risks that we can't anticipate. So we at NASDAQ have focused for several years now on proactive legal assessment. What are the current limitations or gaps, and how can they be strengthened with or without statutory changes? But changing statutes can be a long and arduous process. There are strategic considerations, there are political barriers. So again, we also emphasize the importance of health department discretion as we support our members in structuring internal data release policies in the most protective way possible. And finally, legal relevance. There are evidentiary and procedural barriers to using public health department surveillance data. The health departments are not necessarily the best places for prosecutors to look for evidence, which it seems that they know, because at least we at NASDAQ have had very little knowledge of health departments actually getting these requests, and we have no knowledge of a health department actually releasing the information. But we know that could change as the data evolves, and we all know that prosecutions can happen based on very minimal evidence or manipulated science. So I'm not dismissing those fears at all. And we definitely should be shoring up our data protections to make it impossible, which again is why we focus on proactive legal assessment in our work at NASDAQ. And also why we look at HIV criminal laws alongside our data privacy research, because this helps us to interrogate really what data a prosecutor would really request from a health department and why they would want it and what they could prove with it. So with that, I'm going to hand it back over to Amy. So we've been sitting for a little while, so if folks want to get and take a stretch, that's probably a good idea.
Yes, that's fine. Walk around the room, maybe you're out there walking your dog. Dory really had the heft of our presentation today. HIPAA and state laws governing surveillance or infectious disease data writ large. Those are the bread and butter. Those are going to be the pillars. But we wanted to sort of round out the different statutory schemes, and then I'm going to do this pretty quickly, and we'll use our remaining time for discussion and questions. So I'm going to cover two other statutory schemes, one federal, one state, to round us out. One is the federal regulation that governs substance use disorder data in particular, and then we'll close out with a quick review of minor consent data. And just as a review, and this is really, I always think it's good to kind of have like what is the crux? What is like the core value of the statutory scheme? And I think if you look at really all of these privacy schemes regarding health data, HIPAA for sure, I think the state confidentiality laws with regard to HIV and other infectious disease data, and certainly with 42 CFR, which is the regulation governing SUD data, substance use disorder data, and even minor consent, you're balancing two things, right? You're balancing a patient's right to have their private information confidential, right? That is like an individual right, and that is definitely sort of enshrined in the protections that Dory's gone through and that I'll walk through. And you're balancing that though with this other desire, and this is really, particularly as we have technology that eases the sharing of information. And really, we want statutory schemes that allow providers to share information. In general, it is a good thing when your specialist can share data with your primary care or vice versa. So at the heart of these statutory schemes are really balancing these two things. And we can even add on information sharing among public health programs and practitioners. Like we want data to be able to be shared for public health innovation, for public health practices. So this tension and balance is really kind of at the core of the different statutory schemes. So next slide. So with that, we'll dive into 42 CFR Part 2. I think, NASTAD over the years has touched on this, but we haven't really delved too far into it because it's a bit on the periphery of health department programs, but important nonetheless. And there were actually some recent changes to this protection. But 42 CFR Part 2 is that refers to a federal regulation, and it's a regulation that is specific to protect substance use disorder specifically. And so it's protecting the health information surrounding substance use disorder. And what it protects is fairly limited. It's protecting information that's held by substance use programs that receive federal assistance or federal funding. And I dropped in the quote from the regulation of how we're defining those substance use programs, but Dory described HIPAA and the three categories of covered entities for HIPAA. That's a lot, right? Like that is a big universe. And the substance use realm and the providers and programs that are subject to 42 CFR Part 2, a lot smaller, right? These are providers and programs that are specifically substance use providers, and they're receiving federal funding to do that. So, HIPAA is going to be like the big tent, and then this is going to apply to a subset. So most of the substance use programs are also HIPAA covered providers. The 42 CFR Part 2, because it's capturing a smaller swath of data, it's more stringent than HIPAA. It sort of takes substance use disorder data, much the same way that the new HIPAA protections that Dory just talked about takes reproductive health data, and basically says, this is particularly harmful if it gets released. And so we are going to put more protections around it, right? And so in that way, the protections are going to be more protective, more stringent than HIPAA. So next slide. So I love a schematic, and I will say SAMHSA, and Dory's been sharing a lot of information on HIPAA from HHS and OCR. But SAMHSA, has a lot of good content on 42 CFR Part 2. And so one schematic that I thought, sort of put it in motion and gave a good, if you're like a visual learner, gives kind of a good picture of how it works, is that you've got the community mental health center, right? That's on the far left. Okay. That is, squarely a Part 2 covered provider, right? It's receiving federal funding to provide substance use disorder services. Okay, so they're covered. They have to follow the requirements. And then you've got a psychiatrist, Dr. Madison, who works at that community mental health center, and their patient is Thomas, right? And so Thomas has to consent, sign this consent form that allows his, and it's specific to his substance use disorder data. It is not just a consent that you sign in, similar to HIPAA, which is sort of a broad-based consent. It's specific to his substance use disorder data. And if Dr. Madison wants to share or needs to share that information with Thomas's providers, Thomas has to say, I consent for you to share the data with all of my treating providers. So then, as you can see in this example, there's a health information exchange being used, right? So that's just like, the data hub where the information, all of Thomas's information from all his providers, including from the SUD program, is housed. And Dr. Monroe over there on the right is a treating provider for Thomas. So he's able to access Thomas's SUD records because Thomas has given him permission, because he said all treating providers can access my SUD records. Another doctor who maybe touches Thomas in a different way, maybe it's like an ER doc, it's someone who does not have a relationship with Thomas, cannot access Thomas's substance use disorder services data from the health information exchange. So that's how it works. And that's, when we talk about specific consent for substance use disorder data release, that's what we're talking about. It's very, very specific. It's not a sort of global consent that you use for other medical records. So next slide. And so, when we think about, HIPAA versus 42 CFR Part 2, there's some main differences, right? First of all, and sort of going back to the example we just talked about, HIPAA allows disclosure without consent to other providers for certain purposes. So your providers, HIPAA allows sharing of your PHI across providers as long as it's for the purpose of your treatment, because as Dory said, that's an allowable reason to share data. Whereas 42 CFR Part 2, you need to specifically consent to that, as we just saw in the example with Thomas and his data. HIPAA's exception for release of information for law enforcement purposes is actually broader than 42 CFR Part 2. And the consent requirements are far more specific under 42 CFR Part 2 as well. And so, in particular, going back to our example, the designation of a specific receiving party for the data. So, the takeaway here is that 42 CFR Part 2 is going to have more protections. So next slide. And this has come up a little bit in the past years. Unlike HIPAA, there isn't an exception that says for the SUD providers who have to comply with 42 CFR Part 2, you're allowed to submit identifiable HIV and hepatitis case reports to state and local health departments without someone's consent. So in the HIPAA world, and as you all know out there in health departments, you're getting case reports from providers, and that is within the exception, right? It's identifiable information because it's names-based reporting, but it falls within an exception. So nobody's in violation of HIPAA when they do that. 42 CFR Part 2 does not have an exception like that. And so what that means is that those providers can't send identifiable case reports without consent to health departments. There was talk in this, the 42 CFR Part 2 was just revised not too long ago. There was talk during that revision process of, well, perhaps 42 CFR Part 2 can be amended to allow for this exception. And that is not what SAMHSA did. They did not amend it. They made a slight change and said de-identified data could be shared for public health purposes, but the patient name and any identifying information had to be redacted. So you could still get a case report, but it would not have any identifying information. So it's not super useful for any type of follow-up and linkage and other type of public health intervention that you would use. The last thing I'll say about this, and happy to answer questions if folks have questions about it, is that there's some workarounds here. So I keep highlighting without consent. You could 42 CFR Part 2 providers could build in specific consent forms into their into to sort of how they operate that allow the patients that they see to specifically consent to their case reports for HIV and hepatitis and other reportable conditions to go to a health department, right? You could envision that. That might be a little bit unwieldy, but you could see that happening. There was some talk of like, well, can't the provider just redact its name and send? I think like logistically, that to me seems hard, and it also I think would cut into the information that is going to be useful for a health department to have. But that's another thing that's like a possibility. But those two, so there's some workarounds, but this is where 42 CFR Part 2, one of the ways it sort of bumps up against public health activities because it is so protective and more protective than HIPAA. So next slide. So I'm going to end with minor consent laws, just a brief but hopefully exciting journey through minor consent laws. And this is where we go back to mostly to state law. We'll talk a little bit about where HIPAA comes in, but minor consent laws are mostly at the state level. And the three facets of minor consent that I want to talk about are, one is consenting to the actual treatment, right? The consenting to the service being provided. And in our case, we're focused on HIV treatment and prevention services. So there's the consent to the service. And then there's confidentiality around the healthcare information. So after the service happens and the minor was able to consent to it, what about the confidentiality of that minor's healthcare information? And then the third facet is around payer information. So explanation of benefits and other payer documents, and how or whether the information included in those payer documents is protected, is suppressed, or what privacy protections can we put around there. So I'll go through each in turn. So next slide. So the first one, and I'm actually I'll say CDC, and I'll give them a lot of credit here. In addition to NASTAD, I'm going to share CDC because it's a little bit broader, but NASTAD has also done a lot of work on compiling state laws with regard to minor consent. This one is specific to minor consent to receive HIV and STD services. And so we can drop the link in the chat in a minute. What I'm going to do is just very quickly show it to you. So give me 1 second to do that. I'll pull it right up here. All right. So if you look right in front of you, we'll put the link in the chat. It will take you to this fun page. And if you're sitting out there, there's like 40 some odd of you. So you're in a bunch of different states, presumably. So you can just scroll alphabetically to your state, and you can look at, what are the different ages or statutory authorities for minors. And some states define minors differently, but, basically folks under the age of 18. What are the laws around the ability of that minor to consent to, and we divide it into these basic categories of services. So STD diagnosis and treatment, STD prevention, HIV testing, HIV treatment, HIV prophylaxis, and then sort of a general healthcare services or procedures. And so a lot of state laws are silent. And a lot are actually pretty specific, and especially when it comes to HIV and other STD services. And a lot of states have moved in the direction of specifically authorizing minors to provide consent. And this is consent without a parent's approval and consent. Usually, if you are a minor, your consent is not enough to consent to a wide variety of things, including medical care and treatment. But some states carve out certain services to say, yes, that might be true. Consent might be required from a parent in all of these other areas, but for STD prevention, consent is not required for instance, Colorado, California, for folks 12 or older. So every state's a little bit different, and I would take a look. If there is no statute, then it still may vary by state, and we sort of have to interpret potentially other statutes that are broader. But you can take a look at what CDC has compiled here, and they tend to update this pretty quickly. So this is from 2022. So that I definitely recommend taking a look at that. And we will drop the link in the chat. And actually, I'll do that right now while Dory pulls up the slides again. Okay, so all right, here's the link to that in the chat. And in terms of where minor confidentiality laws bump into HIPAA, and this is where, again, like we have sort of tension points, right? Because embedded within HIPAA and even in most like state case law and state laws, you do have this sort of assumption that a parent steps in legally for the child, right? In many ways, a parent is legally responsible for that minor child. And so our legal statutes and schemes around both consent to services and confidentiality of the minor's data sort of falls under that same general principle where the parent is legally responsible for the child. So if that's like our starting point, then we have to kind of look for exceptions to that overall rule. So HIPAA starts with the overall rule. Generally, HIPAA allows a parent to access the medical records about his or her minor child. And the legal framework that allows that is because the parent is the child's personal representative in that situation. So parent legally responsible for the kid. And there's some exceptions to that. In states that allow minors to consent to HIV treatment and prevention, so again, refer back to that CDC page of where states have given that authority that minors can consent to HIV treatment and prevention. In those states, the parent is no longer the child's personal representative under HIPAA. And so you sort of lose that HIPAA-related automatic entitlement to access the record, right? So that's when you see a state law that says, okay, this, minors 12 and older can consent to, let's say, STD prevention, then there is no requirement that that record be accessible to the child's parent. However, we go back to the states. A state can come back and actually then, sort of override this HIPAA scheme and say, you know what, we actually think that it's important both for minors to have access to certain services and to consent to them, and for the parent to have access to the minor's record. So, you've got this a little bit of a patchwork, and you really do need to kind of look to see exactly what your state says. But that is the interplay between HIPAA and state laws regarding minor confidentiality and minor consent to services. So for instance, some states explicitly allow or require a minor's medical record to be shared with the minor's parent or guardian without the minor's consent. That's going to trump the HIPAA, the HIPAA provision where if a statute allows a minor to consent to treatment, then the parent can have access. A state can come in and say, no, we're going to be more allow the parent to have more access to that minor's data. So you go to the state law. That's going to be really important, and it's going to be very variable across states. So next slide. And then lastly, but not least, we've got, and this has come up, this comes up actually with adults and minors, but, I think it's particularly important for minors who may still be on their parents' private insurance plan. And now with the ACA, they can be on that plan up until age 26. So this is from a table of a really interesting study that was published a few years ago, and we've got the link below, and you just see the different states that actually have a law in place that suppresses minor healthcare data in certain private insurance documents. So, those 5 states either or, and so you've got the 2 columns, either allow a minor to suppress data in an EOB, so, to ask that their data not be included in a private insurer's explanation of benefits, which is like the form you get from your insurer after it pays something for a claim. And then, some states actually even go farther than that and also allow a minor to suppress information for other communication from your plan or payer. So that's sort of the third part. And we don't have a lot of states that do this, but it's certainly it's of interest, and it comes up in reproductive health, STD space, and PrEP for sure. So with that, that was a bit of a whirlwind tour, but I want to make sure we have time to hear from you all. So as Dory said, the Q&A box is right down there on the lower part of your screen. So feel free to put questions in there. And I think, Dory, I'll pass to you to see if we're able to unmute people.
Yes, we can. So if there's something that anyone wants to, I think I would probably have to unmute, give someone permission to unmute themselves, but if there's something that you'd like to share verbally, you can raise your, I think there's a hand raising feature in there. If not, drop a message in the chat and let me know that you want to unmute, and I will keep an eye on that and I will look. Another thing I'm going to do, I'm also going to throw up our responses to the questions from before. Because I thought there were a couple of there were some good responses here that I was wondering if maybe some folks would be interested in elaborating on. One thing that caught my eye, Amy, I don't know if you had a chance to take a look at these yet, was that someone had talked about that they have successfully shared with community partners for various purposes. And we also have folks who are interested in learning more about how to do that. So if anyone wants to share on that topic, it's just an idea. Obviously, folks are welcome to share on anything that they'd like. But I think it would be interesting to hear some of the challenges and successes in that space. Unless folks would rather, talk offline, which we can reach out to folks for that later as well. Not seeing any hand raises. Am I? No, I don't think so. Okay, well, I don't think we had any questions come in except for someone did ask for clarification that we will be sending everything around to everyone, recordings and slides. Yeah, I guess we have some time, so we'll give folks a minute or two to see if anyone is interested in chiming in at all. Amy, was there anything else you wanted to add based on some of the responses that we had here?
Yeah, I mean, I share Dory's curiosity on data sharing with community partners and any trip ups there, and then also strengthening surveillance data and what type of data sources folks are using to do that, and any type of privacy or confidentiality issues they're encountering with that.
No, it was also a lot of information. So if folks kind of think of something that they want to share or talk about after we're done, and oh darn, I wish I brought it up then, we will be having a second session in September. So we can also revisit something from here if there's something you really wanted to talk about, but just didn't feel like today was the right time for you to do that. Reach out to me. I have a contact information slide actually here, which would be a good time probably to share it. I'll also put my email into the chat. So something comes up later that you'd like to discuss or ask at the next session, feel free to reach out. Okay. And we have 5 minutes, so we will stay. And if folks don't want to share or have to leave us, then thank you so much for joining and have a great rest of your day. And please look out for information about our second session. Okay. Well, I guess we could probably, should we call it?
I think so. You know where to find us.
All right. Well, thanks. I see some things coming in. The chat. Well, just thank you all to you for coming today, and we will talk to you soon.
Bye, everybody.